Welcome, everyone. Thanks for taking the time this afternoon to hear about wills and trusts. While this is generally on wills and trusts, I also would like to state that we're going to talk a little bit about powers of attorney, some other kind of estate planning tools. So while this is the overview, there are other topics we're going to touch on today as well. Like Jessica said, if you have questions, please put them in the chat. I will try and answer them as we go. I feel like that sometimes, if I answer it sort of right as they get asked, the answer may be a little bit better. But if I don't get it, we will save some time at the end. So just getting started. The first topic that we're going to discuss today are wills, otherwise known as what's called a last will and testament. And what is a will? A will is I'm not sure why it's scrolling away. A will is a legal document that expresses a person's wishes as to how their property is distributed after their death and as to which person will manage the property until its final distribution. So when we're talking about a will, we have the testator, that is the person who is drafting and executing the will, the person whose property we are talking about distributing. So the testator must be over the age of 18 to execute a will. They must be of sound mind and memory, and the will must be in writing and signed by the testator in the presence of at least 2 witnesses. And so what is important on those witnesses is that there is something in Illinois called an attestation clause. And what the witnesses are saying when they are signing the will is that they saw the testator sign the will, but also that they believed that the testator at the time of signing was of sound mind and memory. Without that attestation clause, wills can be admitted, but it is much more challenging. So those are kind of your main requirements to have a properly executed last will and testament. Does a will control the distribution of all a person's assets at the time of their death? The answer is it depends. So will control what is defined as a probate asset. So not all assets will be distributed through someone's will. So in order for something to be a probate asset, it must be owned solely by the decedent. So let's say you have a bank account that is jointly titled with someone, that will not be a probate asset because the effect of a jointly titled asset is that upon the death of one of the owners, it passes to the remaining joint owners. So let's say I have an account, it names me and my 2 children as joint owners. What happens is upon my passing, the 2 children become the owners. It is not a probate asset, would not be subject to probate or distribution under your last will and testament. So another asset that would not be a probate asset would be something that has a beneficiary designation. Again, that asset would pass directly to the beneficiary upon your death. So the difference between a jointly titled asset and a beneficiary designation is that a beneficiary designation an asset with a beneficiary designation only has one owner. So you would be the owner, but upon your passing, then the asset pays out directly to beneficiaries. Again, that is not a probate asset, would not be subject to a probate estate. So what if a deceased person has probate assets, but they do not have a will? This happens often. So in that scenario, what would happen is that your assets would pass through what's called intestacy. So the state of Illinois has basically a way that assets will be distributed out if you have not made those designations through a last will and testament. So the intestacy law outlines who an heir to the decedent is and who then would take under a probate estate. So if you have a spouse but no children, then all goes to the spouse. If you have a spouse and children, then half goes to the spouse, and then the other half is split by the children that you have. So if you have one child, they take 50%. If you have two children, they take 25 each, and your spouse takes 50%. If you have no spouse but have children, then it's distributed equally amongst the children. And if you have no spouse and no children but have parents, then it goes to your parents, and the list continues. So the way that it works is that, like, ultimately someone will have heirs. It could go all as far back as cousins, but the way that this heirship is established is through what's called an affidavit of heirship. So the person filing to open a probate estate would file a petition saying that the individual who passed away did not have a will, and with that petition would also file what's called an affidavit of heirship. The way I explain that is that it's sort of a written out family tree. So you explain who the heirs are, and then the court would actually make a determination and enter an order declaring heirship. So what is probate? The probate is then a legal process of administering a person's estate after their death. So in order to start a probate process, you would file a petition to admit a will, if there is one, or you would file a petition for letters testamentary for letters of administration saying there is no will and therefore an administrator needs to be appointed. The court appoints a representative. If there is a will, that representative is known as the executor, and the executor is named in the will. So when you are drafting a last will and testament, one of the things that you put in there is who do you want to be actually managing your probate estate and distributing the assets. If there is no will, the court appoints an administrator. And the administrator, there is a hierarchy under the law as to who can nominate an administrator and then who can act as an administrator. So under that hierarchy, the court would then say, this person has preference to nominate an administrator, and therefore I am appointing the administrator based on their petition. Ultimately, though, it goes before a judge, and the judge is going to appoint an administrator or an executor to act. The representative is responsible for identifying and inventorying all of the assets of a probate estate, paying debts and taxes, and then ultimately distributing the remaining property according to the will, if there is one, or according to the laws of intestacy, if there was no will. So probate typically involves paperwork and court appearances by an attorney. In every probated estate, it will take at least 2 court dates to open and close the estate. Sometimes it takes more. Once you open a probate estate, your attorney would run a creditor claim period. By law, a creditor claim period lasts for 2 years after the death of the decedent, but that can be shortened in a probate estate by publishing to unknown creditors. So what happens is that we run a publication in either the Chicago Law Bulletin or some other legal publication that notifies all creditors of that there is a probate estate open, and if there are any claims against the estate, they need to be made within 6 months of the filing of the public or the running of the publication. So you can shorten your creditor claim period in a probate estate from 2 years to 6 months. A probate estate is a public proceeding, so all of the documents filed in a probate estate are public record. It is held in an open courtroom that anyone can attend. So there, First, when we're talking about wills and trusts, and when we are doing estate planning for people, that is sometimes a consideration, is that some people don't want uh, their probate estate to be public. And so trusts are generally not held in court. They all take place outside, or trust administrations, they all take place outside of court with no judicial oversight. So those are not public proceedings generally unless there is a trust contest or trust action filed in a chancery court. Also, if you have an estate under $150,000, that can be administered without a probate estate, if through what's called a small estate affidavit. So the small estate affidavit is a form that's filled out by someone basically saying, these are the assets of the estate. They are under $150,000. These are the creditors to the estate, and I, as the affiant, will be paying those creditor claims. So it allows for the administration of an estate without having to go through the court process of administering through a probate estate. So property that does not go through probate. So as we discussed, any jointly titled assets would not travel through a probate estate, because again, they go directly to the other joint account holders, or anything with a beneficiary designation. Those, again, upon the death of the owner, the financial institution, wherever those are held, they are going to send in your beneficiary forms. You have to present them with a death certificate, and then the beneficiary, the policy pays out directly to the beneficiaries. Those are generally, I mean, you can set those up on bank accounts. Generally, if you have an IRA or any sort of retirement account, they are going to require that you have a beneficiary designation on those. Life insurance policies, annuities. So you can name beneficiaries on most accounts as a way of avoiding a probate estate. And you can also name primary, secondary, or tertiary beneficiaries. So let's say you've named a beneficiary and they pass away, you can have a secondary sort of backup beneficiary directly on your account. Another asset that would not be a probate asset would be any asset titled in a trust. And so we're going to get a little bit more into trusts down the road, but if you have a trust and you have properly funded your trust, meaning that your accounts are titled to your trust, those would not be probate assets. So when you're thinking of what would be a probate asset that would travel through or go through my last will and testament, it would be anything solely in your name that does not have a beneficiary designation and is not titled to a trust. So we're going to talk about some sort of alternative ways to distribute your assets other than through a last will and testament or a probate estate. As we discussed, one of those is joint tenancy. So that would be, you go to the bank and you set up a bank account and you, let's say, add someone onto that bank account. I think it gets kind of done very often in a way that people might not understand the legal ramifications of that. So I do like to get into that, because what I think sometimes is misunderstood is, even if you're adding someone to an account that belongs to you, is completely funded by you, it's all your money, the moment that you add someone on as a joint owner, each of the owners owns 100% of the property. So even if that is all your money, it is funded all by your income, a joint owner has the right and the ability to come in and basically take all of that money, use all of that money for themselves. And I have seen that play out in ways that I think are unexpected for some people. So at the death of one of the joint owners, the surviving owners own the entire property. So it is an effective way of avoiding probate. And so the advantages of that is it avoids probate. It is no cost to set up. You can go directly to the financial institution and add a joint owner. And it arranges an estate so that others would be able to manage your assets during incapacity. So let's say there is a situation in which you become incapacitated and you have a joint owner on your account. your joint owner then can access your funds immediately and use those funds to pay for your care. So that would be an advantage. But there are some disadvantages. One of those is that it is risky. As we discussed, the joint tenancy ownership gives not only the joint owner full access to the property, but it also allows creditors of the joint tenant to come after that account. So in the scenario, let's say I've set this up with one of my children, and one of my children then has a creditor. Because they own that account 100%, even though I haven't co-signed anything or had anything to do with that creditor technically could come and seek payment from that account. So it not only gives joint ownership to someone else 100%, but it also would allow their creditors to attach to those funds. It does not allow for contingent beneficiaries. So if the joint tenant predeceases you, then you can't sort of plan for the future in the same way. So if your joint tenant predeceases you, then your plan has sort of failed as to where it goes. Also, if you've reached an informal agreement, let's say you've got an informal agreement you've got multiple children, but you have one child on as your joint owner for convenience purposes. Let me just help pay the bills. There is no obligation for the joint tenant to give those funds to the other people that through the agreement that you had. So even if the agreement was, yes, of course, you're going to split this money upon my death with all of your siblings, there's no obligation for them to do so. And really, there are no legal ways to bring that account back in or bring it into a probate estate, because the legal effect of joint tenancy is to make that other joint account holder the sole beneficiary upon your death. Again, so for Medicaid as well, the Medicaid applicant is presumed to be 100% owner of all of the personal joint property. So let's say your joint tenant needs Medicaid. Again, this would be a scenario where, let's say this is all your money, they're on for convenience purposes, but they need a Medicaid application. Illinois Medicaid is going to look at that asset as theirs. So they're going to say, well, this is an asset that then needs to be used for the benefit of the joint tenant prior to them maintaining Medicaid eligibility. So that could be a problem if you're in a 5-year look back period where your joint tenant is needing Medicaid. So a way to sort of get around some of these issues would be to have a power of attorney for property as opposed to naming someone as a joint tenant on your account. So powers of attorney are legal documents that allows you to appoint a person or organization to manage your property, financial, or medical care. In Illinois, we have 2 types of powers of attorney. We have POAs for healthcare and we have POAs for property. A healthcare POA allows another person to make medical decisions, and then a property POA allows for management of all principal's property. That includes real and personal property. So we talk about real property is your buildings, places that you own. Personal property are your bank accounts, and then tangible personal property are your things. So in a power of attorney for property, you are naming an agent to manage all of those things. So in powers of attorney, we have the principal, who is the person signing the document and giving the power to someone. And then the agent is the nominated person or entity who is appointed to legally act on the principal's behalf. Powers of attorney require what's called legal capacity to execute them. So powers of attorney are contracts. So in order to effectively sign that contract, we are looking for whether the individual has the ability to understand the nature and effect of the document and the transaction. So did did the person actually understand when they were executing a power of attorney that they were giving someone else the eventual power to step in and make decisions for them. In Illinois, anyone over the age of 18 is presumed to have capacity to sign a contract. And so that presumption can really only be overcome by a finding of incapacity by a court or an adjudication of incapacity. So under a power of attorney, the principal can only name one person to act at a time and cannot name co-agents. That's on the statutory form. There in Illinois, you can do what's called a non-statutory power of attorney, but the statutory form is really preferred. And the idea behind that is that you don't want to have two people who have the same authority to act, because it really can create confusion, especially with medical care, or let's say in financial situations, if you have two people going to a bank saying they have the same authority, it can really become confusing. So Illinois prefers that it's only one person acting at a time. And if you have two agents named on a statutory form, it is going to be ineffective. So what we do have, though, is that you can name successor agents. So on your power of attorney, you can name an agent who is first situated to act, and if they are unable or unwilling to act, then you can name a successor agent. So it says, if my agent is unwilling or unable, I name this person and then this person, and you can have as many successor agents as you want on the document. And I think that that is important because you've gone through the time and energy to do these powers of attorney, and you have customized exactly who you want to be the person acting for you. And so you want to make sure that your document stays effective and stays relevant, because otherwise, if you have a power of attorney and it names agents, but none of them are able or willing to act, you could end up in a situation where, again, you have this document that you've done, but no one can actually act on your behalf. Powers of attorney can be customized to any situation, really. So you can make them for specific transactions, time frames, or it could be a long-standing estate planning document. A good example for specific transactions are real estate closings. So when I purchased my condo, or I guess it was my sale of my last condo, I didn't want to go to the closing myself. So I did a power of attorney nominating my real estate attorney to act on my behalf for that specific transaction, for that specific time frame. It was like 2 days, and giving them the authority to sign all of the closing documents on my behalf. At that point, the power of attorney was no longer effective, and it was done. So it was for that very limited transaction and for that very limited time frame. You can do them power of attorney for healthcare if you are doing a surgery and you want to nominate someone to act for you on your behalf if you're unable to, for just that very specific time. But many people do them as long-standing estate planning documents for if at any point in the future you become incapacitated and you are unable to make your healthcare or financial decisions, that document then allows your agent to step in, access your bank accounts, pay for your care, make medical decisions for yourself, and then it basically lasts until you pass away or until you revoke the document. Powers of attorney can be effective immediately, or they can spring into action upon an occurrence of incapacity. So, and in many situations, powers of attorney can be effective even when you have capacity to make your own decisions. So in some situations, people come to us for estate planning and they say, you know, my son has already been kind of helping me pay my bills. They're completely competent, able to make their own personal and financial decisions, but just for the ease of, not having to do that, they want to make their power of attorney for property effective immediately. And at that point, then your agent can add themselves to your bank account in that role as agent. So it then solves the problem of having someone with the authority to act on your behalf, have access to your money, but then your agent is in a fiduciary role. So they are not an owner of your bank account in the same way that they would be if you set up the joint tenancy. And they also are supposed to be acting only for your benefit. And they are in a fiduciary role, meaning that if they do something that is not for your best interest, they can be removed by a court. And there could be legal ramifications for them doing that. The springing power of attorney is usually upon a physician's certification of incapacity. So that means this document does not go into effect until you get a letter from my doctor saying I'm no longer able to make healthcare decisions or financial decisions, whichever document we're referring to. Executing a new power of attorney revokes any old powers of attorney. So if you are signing a new statutory form, the first thing it says on there is that this power of attorney revokes any previous powers of attorney that I have done. So when you do that, it always is important to, though, let your old agent know. Let's say you have a power of attorney naming an agent and you sign a new one. You want to ensure that the old agent is aware that they no longer have the ability to act on your behalf, so they don't think that they have that authority anymore. So the powers of attorney, or the powers of the agent defined in the statute, are very broad unless they are modified in the document. So if you look at the statutory power of attorney for property, it names, like, it's like A through W or something as far as the types of transactions that you are authorizing your agent to make for you. It's real estate transactions, banking transactions, tax transactions, stocks, bonds, really kind of anything that you could think of is kind of covered in that document. But what you can do is you can customize the document. So back to the example as to the real estate closing. In that, it was for that very specific purpose. And so you cross everything else out and you just say, this is for this specific purpose. Or if there's something that you feel comfortable with your agent doing, let's say it's everything except for you don't want your house sold unless a court gets involved. You can take the real estate transactions out of there. So powers of attorney for property are highly customizable. But if you don't customize them, like if you don't scratch out any of those things or say what the limitations are, you're giving very broad authority to your agent to act in your stead. There are certain actions the agent cannot take unless the power is added to that document. So that would be the power to make gifts, power to change beneficiaries, engage in any amendments to your trust. All of those things would need to be affirmatively added to the document for your agent to have those types of powers. I think the biggest one of those is gifting. The agent must be acting in good faith, using due care, competence, and diligence in acting for the principal. And in powers of attorney for both healthcare and property, your agent is supposed to use what's called substituted decision making. So they actually step into your shoes and should be making decisions consistent with what they believe you would want, not what they believe is in your best interest. So if they're not able to determine what you would want specifically, then you do go to a best interest determination. But when I represent agents, I'm always asking them, what would the principal want? This is not a decision about what you believe is best. Do we know what they would have wanted you to do for them? Because as the agent, you are stepping into the shoes of the principal and acting on their behalf. So other protections really that are set up under the Power of Attorney Act is that agents must keep a record of receipts, disbursements, and other significant actions. So once you start acting as an agent, it is your duty to really be able to account for every penny in, every penny out. So once you sort of start acting, you could be asked by a court, Adult Protective Services, the Ombudsman, Public Guardian's Office to provide an accounting of your actions as agent. So this is, again, you are acting as a fiduciary, and it is a requirement under the statute that you be able to account for those actions. An agent can delegate authority to others, and under the Power of Attorney for Property Act, you are also entitled to reasonable compensation as an agent. With that, though, there needs to be some sort of ability to track that. So you can't necessarily just take some fee and say that that is my reasonable compensation. We always suggest that, you're keeping a time log of what you're doing. And what is reasonable also depends on a case-by-case basis. So when we're talking, if you're in a guardianship and you're asking for a guardianship fee, what I usually tell clients is the court is not going to approve more than $25 an hour. What is reasonable under the Power of Attorney Act might be slightly different than that, but that's at least a good guideline to operate under. So now moving on to trusts. So what is a trust? A trust is an entity created to hold assets for a beneficiary. So it's a legal container that holds money or property, and you can put anything into a trust: cash, stocks, real estate, a business. And what a trust does then is that it operates for the benefit of a beneficiary. And the rules and instructions under which a trust operates are set out in the trust instrument itself. So if someone is talking about they have a trust, or there's, some trust that we're looking at or something, I'm always like, I need to see the trust. You have to read the document to see what it says, who it names as the beneficiaries, what the rules are related to the trust, because every trust is, again, customizable. So highly customizable by the grantor of the trust, the person who sets it up. And so in order to know how the trust operates, you have to review the trust agreement itself. And there are different types of trust, and we'll get into that a little bit further. So when we're talking about the trust, the grantor of the trust is the person who creates the trust. They could also be referred to as a settlor or a trustor. The trustee is the person or firm or entity that holds and administers the property or assets for the benefit of a third party. So the trustee acts as the custodian of the assets held within the trust and is responsible for managing and administering the finances of a trust. And then the beneficiary is an individual or group of individuals for whom a trust is created. I think the thing that gets a little bit confusing about a trust is that at the beginning of a trust, the grantor, the trustee, and the beneficiary can all be the same person. So I can execute a trust, name myself as the sole trustee and also the sole beneficiary of the trust. And generally that's what people do at the outset when they're setting up a revocable living trust, is that while they are the grantor, they are also putting themselves in the role of trustee, and they are the sole beneficiary until they pass away. That is not necessarily always the case, but that is generally, I think, how most people, when they're coming in doing their first time trust, that's how it's being set up. But you don't have to do it that way. You can be the grantor and you can nominate a bank, you can nominate someone else, you can nominate a co-trustee to act with you. You could also set up a trust where you are making someone else the beneficiary, sort of a separate trust. So there are trusts, again, highly customizable for whatever needs you are trying to accomplish. So types of trusts, there is what's called a revocable trust, where a grantor can change or cancel the trust if he or she is still alive. I would say alive / not incapacitated. So let's say you have a trust, you have named certain beneficiaries after your passing, and you'd like to make a change to that. A revocable trust can be changed at any time until the person passes away, or in some instances becomes incapacitated. Incapacitated, yeah. So a revocable trust, you can change the trustee, You can change your beneficiaries. You can terminate the trust. You can say, I don't want this trust anymore, and you can completely terminate it. So that is a revocable trust. An irrevocable trust would be a type of trust where the terms cannot be modified, amended, or terminated. So special needs trusts are typically irrevocable, meaning that once you have signed it and funded the trust, the money is in there and it must be administered through the trust document and cannot be changed or revoked. A testamentary trust is a trust created by a will. So in a last will and testament, you can actually set up what's called a testamentary trust, which then doesn't go into effect until the testator passes away. The will is probated and the probate estate is open, and then the testamentary trust goes into effect. So revocable living trusts, that's going to be generally the type of trust that most people are setting up. Um, the trust allows the trustee to administer and invest trust property for the benefit of one or more beneficiaries of the trust. A benefit of that is that it avoids probate. So upon the death of the person who created the trust property passes to whoever is named as the it's usually the remote beneficiary or contingent beneficiary of the trust. So the way that most trusts are set up is that the grantor during their lifetime acts as the trustee and is the sole beneficiary. Upon their death, then the trust is going to say, I then name these people as the beneficiaries, and the trustee should administer the trust to them either outright, or it sets up subtrust for future administration of those trust assets. So one of the benefits is that it's not subject to probate, and the distributions do not need to go through the probate process. There are some benefits for tax planning for in a revocable trust. So trust can be drafted so the assets will not be included in the estates of beneficiaries and therefore avoiding taxes when they die. You can create separate trusts upon your death for your trust beneficiaries. So you can either allow for the trustee to distribute outright to your beneficiaries, or again, you can set up subtrusts that will kind of limit how those assets can be distributed to your beneficiaries by the trustee. You can put age limits. So let's say you have children who are under the age of 25 and you want them to only get certain distributions until they turn 25 or 32 or whatever the age is that you want to put on there. The trustee can manage those assets for them until they hit that age, and then at that age they could be distributed the trust assets outright. The trust also allows you to plan for incapacity. So last wills and testaments only provide for your assets at your death, and a trust can help a person have a plan in place for their own illness or incapacity, and it could also help you avoid guardianship. I will also point out that powers of attorney will help you avoid guardianship. So another reason why powers of attorney are so important is that if you become incapacitated and you have named an agent under power of attorney for healthcare and property, that they can then step in and make decisions for you. If you don't have those documents set up upon your incapacity, what could happen is that a court may need to be involved and a guardian appointed, because if you're unable to make your own personal and financial decisions and there are no legal documents authorizing someone to act for you, a court may need to appoint a guardian. So why would someone create separate trust for your heirs or beneficiaries? So it can allow for the limit or control of access to funds based on a beneficiary's age or spending habits. So another reason why sometimes sub-trusts upon death are set up and the assets aren't distributed outright is that there's some concern about an heir's spending habits, or concern that if they receive all of their trust assets outright, that they will not manage them well. So you can put some guardrails against around that and authorize the trustee to just pay them income or to make distributions on a discretionary basis, meaning that it's the trustee who you have entrusted with that power who gets to ultimately make those decisions as to how the trust assets are distributed. You can also create special needs trust for disabled beneficiaries. And the benefit of a special needs trust is that it allows for your disabled beneficiary to continue to receive their benefits. So let's say there's someone who is on Medicaid. And they're receiving Medicaid benefits. It allows them to continue receiving those, but also receive this inheritance through the trust. There are going to be some special qualifications as to how that money is spent and distributed, but it allows for someone who we know is disabled and really needs those benefits to also receive an inheritance. There's also creditor protection for your heirs if you set up separate trusts, and then it can also protect your heirs' assets in a divorce. So revocable trusts and incapacity. So what happens if you become incapacitated and you have a revocable living trust? So with a revocable trust, there will be a clause that triggers a successor trustee to act. So that sometimes would be that same physician statement of incapacity. So it'll say that I am the acting trustee of this trust, and the successor trustee can only step in if I resign or there is a statement by a physician saying I'm no longer able to act on my own behalf. If that happens, then the successor trustee can step in and start acting on your behalf. You can name a spouse, a child, or a corporate trustee to act as your successor. And again, this, like when we discussed in the powers of attorney, you would want to have probably multiple successor trustees named. You always want to make sure that there is someone in line to act. If there's not, there's always a court process or some other way to get a successor trustee appointed. But in these scenarios, the idea is that you want to make the decision as to who's going to step in and be managing your trust if you are unable to or when you pass away. So the a trustee is a fiduciary. So same as your agent under a power of attorney for property, they have a legal obligation to act in the best interest of the beneficiary. So why would you want to choose a corporate trustee? So the duties of a trustee are to prudently invest and administer the trust assets. They have a loyalty to the trust beneficiaries, so there's no self-dealing, and they account to trust beneficiaries in compliance with the terms. So the benefit of a corporate trustee is that they do this. This is what they are in the business of doing. And so they kind of know the rules. They have no interest in self-dealing. So some people choose a corporate trustee, and it also can sometimes take away of some potential, drama within a family. Is that if you have named one of your children to manage the money of your other children moving forward, that could cause some strife. So sometimes individuals pick a corporate trustee to act for them if some of those things sound like that they would be beneficial in their circumstances. So the trustee owes a high standard of care, prudent investments. They'll have complete and accurate records. They can get tax filings done. Um, and yeah, I sort of already went over this. Family conflicts. They have the skills to manage these processes. They will also be updated on any changes in the law, and they have expertise in handling communications with beneficiaries. Um, So some of the things that are important when we talk about corporate trustees, though, is that they are going to collect the assets and manage them all in-house generally. So if you have a special financial advisor that you're using at an institution and they fall outside of the of that corporate trustee who you named, the corporate trustee usually brings in all of the assets to manage in their own portfolio. That does make sense in many cases, so they know what the assets are doing and can better plan for how they are administered. They are going to charge a percentage of the market value of the assets under management. So their fee will be laid out in a fee schedule. So each corporate trustee is going to have their own separate fee schedule. And that would be something that you would always want to discuss prior to naming a corporate fiduciary. All of the fee schedules are very clearly laid out and accessible. And they go up based on or really the percentage goes down based on the value of the total trust assets. And then the fee covers the management of the assets, the accounting, record keeping, and bill payment. So the trustee should be handling all of those things once you have entrusted them with that duty. Let's see, there was something else I wanted to discuss with trustees. I can't remember, so I'm going to move on, but if I think of it, I'll come back. Oh, I remember. So for trusts, while you can set up a trust, and many people set up trusts and then they have to be funded. So you can have a trust, and again, it is basically a holding place for assets, but you have to get your assets into the trust or properly fund the trust. So when you leave an estate planning signing at my office, what you're going to leave with is an executed trust. So you're going to have that trust, it's going to be there, but unless you actually make the steps to title your assets into your trust and move them over to your trust, you're going to have an unfunded trust. So it's always very important if you have a trust to make sure that you have retitled your assets into your trust. Because really the only thing that my office or I'm going to help you do in an estate planning appointment is to, if you own real property, we'll do a deed. We'll get the trust, we'll get your real property into the trust. But everything else, your accounts with, Chase, Morgan Stanley, all of those, you're going to have to contact them and say, I set up a trust. I need to change it. I need to actually title the assets to the trust. Because what happens is if you don't fund your trust, if your assets aren't actually put into the trust, what happens is that upon your death, you have an unfunded trust. And then the other thing that you would be signing during an estate planning appointment with us would be what's called a pour over will. So your last will and testament is going to give everything to your trust. So it's sort of a catch-all to make sure that if there are assets that never get into the trust or sort of, like a asset gets missed, that it allows for the transfer of the assets to your trust for ultimate distribution. But what happens is that if you have an unfunded trust and you pass away, your executor and your trustee are still going to have to go through the probate process to have your will admitted to probate. It's going to say the beneficiary of this will is the trust, but you still have to go through the whole process of having a probate estate. So properly funding your trust is very important. And, that's something that, of course, we discuss in our estate planning appointments. But, just even if you have a trust, it's just something that I always want to mention in these presentations, that ensure that you actually have titled your assets into your trust, even if you have one. So when you get those statements, instead of it saying Amy Gjesdahl and my address, it usually would say something like Amy Gjesdahl, trustee of the Amy Gjesdahl Revocable Trust, in some sort of abbreviation. But there's generally some designation that you're going to be able to see that your accounts are titled to your trust. You use them in the exact same way. There's not really any other requirements, but you want them titled into your trust as opposed to in your name individually. So moving on to special needs trusts. Special needs trusts are, oh, that slide's blank for some reason, is a trust for the benefit of a disabled beneficiary, which preserves their public benefits while allowing for disbursements for their supplemental needs. So this is a type of trust that would allow a disabled beneficiary to continue to have assets, but also allow them to get public benefits. Absent a special needs trust, a person with disabilities can only receive public benefits such as Medicaid or SSI, and they can have, it's that number is wrong, I should have changed that. They can only have $17,500 in assets. So that amount went up. And so it's now 17,500, but that is the limit unless you have properly set up a special needs trust. Let's see, we've got a question. What does one do if you have no heirs or anyone who could act as a trustee? So as far as your heirs go, if you, they don't have to be, when you're setting up a trust or a will, you don't have to name family members. The benefit of having a trust or a will is that you can name anyone as a beneficiary. It doesn't have to be your family members. And, you know, if there are no individuals who you want to give your assets to, charities are always an option. So in a will or in a trust, you can name a charity, and you can name specific charities, or you can leave that up to your trustee to make that determination. And then if you don't have anyone who could act as a trustee, the idea of a corporate fiduciary, so a bank in essence, they can do it. There are also professionals who handle powers of attorney and trustee administration. So there are some individual people who have businesses where they will act in that fiduciary role for people. So there are different ways to handle that. Okay, so for special needs trusts, we have what are called first party funded special needs trust and then third party funded special needs trust. A first party funded special needs trust is funded by a beneficiary's own assets. They can be used for personal injury settlements, assets that were accumulated during their lifetime, or a direct inheritance. So for a first party special needs trust, there is a Medicaid payback after the beneficiary dies for benefits paid out during their lifetime. Usually you're going to hear these called an OBRA trust or a special needs payback trust, usually a OBRA trust. And then a first party special needs trust would be created by for a disabled person under 65 by a grandparent, legal guardian, or a court under that's first party. So that would be created by that person. And then a third party special needs trust does not have that same payback provision that a first party has. So it is funded with assets not belonging to the beneficiary from a parent, grandparent, or a gift by a family member. There is no Medicaid reimbursement requirement upon the beneficiary's death, and the remaining funds can be designated to other beneficiaries. You can establish a third-party special needs trust in your own estate plan. So let's say you have a revocable living trust. You can set up a third-party funded special needs trust within that upon your death. Your will could create a special needs trust. And then special needs trust for people who are 65 or older. So in Illinois, this is only available for people who are wards of the Office of the Public Guardian or Office of the State Guardian using a pooled trust. And because so if you're over 65, you're going to incur a penalty to do this. If you're under 65 or under the public guardian's care, you can do a first party funded special needs trust. So I am going to wrap this up and save a couple minutes for questions because I see I already have 3. So I'm just going to move to the end here. Oh, well, let me stop here. Do one quick. So for special needs trusts, there are only certain types of distributions that you can make. So there are guidelines as to how this money can be spent. And while this list is not exhaustive, I think it is a good example of sort of things that you can use your special needs trust money on. So for caregivers, handicap accessible vehicle, care manager, co-pays, dental expenses, legal fees, vacation, educational expenses, assistive technology. What is very clear though is that you can't give money directly to the beneficiary through cash. So you could do a TrueLink card, but the funds need to be paid out to the provider or to the entity then the disabled person is receiving the benefit from. So there can't be a direct distribution of cash to the person, to the beneficiary who is disabled.